Hello and welcome to this episode of Law for Lawmakers. I'm Fiona Rutherford, Chief Executive of Justice, the UK's law reform and human rights charity, working to create a fairer justice system within everyone's reach. This podcast is based on our Law for Lawmakers guide, which helps repair the cracks in the UK's political foundations by giving every MP the tools they need to act as custodians of our democracy. The guide explains key legal and constitutional principles to help politicians of all parties and their staff scrutinise legislation, assess its legality, table and write amendments, support their constituents, and hold the executive to account. But this podcast isn't just for parliamentarians. It's for anyone who cares about how our laws are made and what Parliament's role is in upholding the rule of law, including how justice is delivered in practice. Each episode brings together leading voices from law, politics and public life to explore the principles that underpin our constitutional system and the practical role that Parliament plays in upholding the rule of law. This special episode of Law for Lawmakers was recorded live at the Justice Annual Conference last November, kindly hosted by A&O Sherman. Today, we hear judicial perspectives from across the UK, bringing together senior voices from three of our distinct legal jurisdictions to reflect on the rule of law, constitutional principle and the challenges facing the justice system today. Our speakers are Lord Briggs, Justice of the UK Supreme Court, Lord Justice McCloskey, Lord Justice of Appeal in Northern Ireland, and Lady Carmichael, Judge of the Court of Session in Scotland. Together, they offer a rare judicial review from across the UK, exploring how shared principles are applied within different constitutional and legal contexts, and what that means for lawmakers, institutions and public confidence in the rule of law.
First of all, we're going to hear from Lady Carmichael, who is from the Court of Sessions in Scotland. Secondly, we're going to hear from Lord Justice McCloskey from Northern Ireland. And then we are going to hear from Lord Briggs from the Supreme Court of the United Kingdom. And the idea of the session is really to give all of us an idea of what your perspectives, your different perspectives are from the jurisdictions that you sit in. And it's increasingly important, I think, that we understand as a United Kingdom what the different perspectives and how the Human Rights Act has, in particular, had an impact on your individual jurisdictions as well as across the United Kingdom. We're going to start, Lady Carmichael, with you, and we'll go down in order.
Yes.
Please do, wherever you're most comfortable.
Thank you. Well, when they said they were going to video this event, that was before I knew I was going to face plant into Gray's Inn Road earlier on today, so apologies for the appearance. I've been asked to speak today particularly about the incorporation of the Convention rights in the context of the Scottish devolution settlement. As an old friend very kindly reminded me the other day, it was 39 years last month since he and I started at university. And public and administrative law in Scotland look very different today from how they looked then. The Scotland Act and the Human Rights Act, both enacted in 1998, are two very significant developments that came more or less hand in hand. The Scotland Act, which came into force a little before the Human Rights Act was fully in force, created a Scottish Parliament and placed a number of limitations on its powers. And my focus is on the limitations that it imposed on both the Parliament and the executive by reference to convention rights. Section 29 of the Scotland Act provides that an act of the Scottish Parliament is not law if any provision of the Act is outside, or rather insofar as any provisions that the Act is outside the legislative competence of the Parliament. And one of the limitations on its competence is that it can't act in a way that's incompatible with the Convention rights, and that is the Convention rights as defined by the Human Rights Act. And similar various controls were placed on the executive so far as governmental action of various sorts and also the creation of subordinate legislation were concerned. Now, as will be obvious from what I've just said, the framework for convention rights challenges to acts of the Scottish Parliament is very different from that which applies to complaints about the compatibility of acts of the Westminster Parliament with the same rights under the Human Rights Act. And so it's under the Scotland Act that a great many convention rights challenges have been brought in Scotland. The very first act of the Scottish Parliament, the now repealed Mental Health, Public Safety and Appeals Scotland Act, was said to be incompatible with Article 5, a proposition rejected both by the Court of Session and the Judicial Committee of the Privy Council, because that, when devolution started in Scotland, was the appeal route where there had been references of devolution issues. There have been a number of challenges to Scottish legislation over the years, most of which, it has to be said, have been unsuccessful. Two examples of success include Salveson against Riddle, which related to the compatibility of legislation about agricultural leases, incompatibility with A1P1, and a case in 2016, Christian Institute against the Lord Advocate. That's a case that involved a challenge to provisions under which every child in Scotland was going to get a named person. And the challenge that succeeded ultimately was narrower than that brought by the petitioners, which was pretty much a root and branch challenge to the legislation. What succeeded was a challenge relating to the provisions for information sharing about children. And that challenge succeeded on the basis that the provisions lacked the clarity necessary for accordance with the accordance in the law requirement of Article 8. For those with an interest in interventions, and I think some of you here may have, it may be relevant to note that it was on that focused point only that the intervener made submissions, and I say that with a shy smile because I represented the intervener in that case. Convention rights have been used in Scotland to challenge governmental activity in a variety of fields, including prisoners' rights. Fairly early on, we had a challenge to the practice of slopping out, the lack of in-cell sanitation, which resulted in modest awards of damages, but long-lasting change to the structure of Scottish prisons to the benefit particularly of the remand prisoner population. Many convention rights cases in Scotland in the early days related to criminal procedure and in areas sometimes where Scottish procedure was different from English procedure. The first thing to say about that is that it was entirely new for Scots lawyers to have a right of appeal to London in any criminal case. That simply didn't exist. So it was a bit of a shock to the system for some. And challenges were brought initially on the basis, really, that the Viry's control on the executive applied to the Lord Advocate, who's also the chief prosecutor, but a member of the government as well. Ultimately, there came to be some legislative change in relation to how those issues are dealt with, but there is still a route of appeal to London in some criminal cases where convention rights or other limitations on power under the devolution settlement are concerned. Now, in fact, we're in Scotland awaiting a decision next week from the Supreme Court in a case about the compatibility of the rape shield measures in Scotland with Article 6. Some of those early challenges, though, moved matters forward in Scotland in a way that I really don't think would have occurred without direct recourse to convention rights in domestic law. Two of the more significant challenges involved a finding that the arrangements for temporary sheriffs, that's circuit judges in English, were not compatible with Article 6, led to a change in terms and recruitment for fee-paid judges in Scotland. And perhaps the biggest one was, it comes as a surprise, I think, to practitioners in England and Wales, but for a long time we didn't have a requirement that, that suspects had to have access to legal advice before being interviewed by the police. And in 2010, the Supreme Court in Cadder applied saldos against Turkey, and things changed in that regard as well. Although I've been talking about the Scotland Act as the main avenue of challenge, there are of course many public authorities where the route in Scotland is to use the Human Rights Act as well. Local government, for example, an area where there's been a great deal of activity in Scotland is in relation to Article 8 and our children's hearing system. That's a system that deals with allegations of criminal conduct against children, but also is the first public law stop for children in need of care, guidance and protection. A recent example shows how we can have both sets of provisions coming into play in the same case. In A against Principal Reporter, we had an order itself actually a result of an earlier Supreme Court challenge that gave all natural fathers the right to come to children's hearings. That brought with it some problems in relation to a father who had no established family life and in fact was in jail for very serious crimes against the mother. And the contention was that the Article 8 rights of mother and child were breached by the father's access to what would otherwise be their private information. So we have the Scottish order being looked at as, well, is that within the powers of those who made it under the Scotland Act? And we also have the argument about the duty on the children's hearing itself as a public authority to act in a way that's compatible with the Convention rights under Section 6 of the Human Rights Act. So that's that's an example, I suppose, of how we see them interact, the different provisions sometimes interacting in Scotland. I've been asked, and I'll say just very briefly now, a little bit about the incorporation of other instruments in Scotland. You may be aware that Scotland took steps to incorporate the United Nations Convention on the Rights of the Child. There's an act from last year. The bill, on its way to becoming an act, passed through the Supreme Court because there's a provision for referring provisions that may be out with competence. The bill was, in fact, out with competence in some ways because it impinged on the preserved power of the UK Parliament to legislate for Scotland. And that explains why we see the Act framed the way that it now is in relation to what functions by public authorities in Scotland are caught potentially by incompatibility with the UNCRC rights. It's broadly in relation to devolved matters and under Scottish legislation. So far, we've only had one judicial decision on that. And finally, and I think still just within my 10 minutes, Fiona, since 2018, Scottish Government has been engaged in considering bringing forward legislation to incorporate other treaties, the International Covenant on Economic, Social and Cultural Rights, the International Convention on the Elimination of All Forms of Racial Discrimination, the Convention on the Elimination of All Forms of Discrimination Against Women, and the Convention on the Rights of Persons with Disability. And they also say they're considering quite a wide-ranging set of environmental protection rights under the same umbrella. The most recent discussion paper about that came out, I think, in August of this year. We still haven't seen draft legislative provisions there. I can't predict what the legislative landscape will look like for human rights in another 25 years. I do have little doubt that in all the jurisdictions represented today, lawyers will be bringing issues about fundamental rights and freedoms before the courts. And I also have no doubt that they will be doing so in a landscape that has been shaped very significantly by the legislation that we're all talking about today, and that we've been working with for the last 25 years.
Good afternoon, all. It's a delight to make this brief presentation to you in this, the graveyard slot of this momentous occasion. It won't have escaped your notice that I'm not from England or Scotland. I'm from Northern Ireland, that tadpole in the northwestern part of the United Kingdom with a population of just under 2 million, and one which we're frequently reminded is about half the population of Yorkshire. That fact in itself has some significance for what I'm going to say at something of a gallop. On the 8th of March 2025, the Supreme Court of the United Kingdom gave judgment in the case of JR 23. Pause. We've anonymised an awful lot of our judicial review applicants in Northern Ireland for a variety of reasons, but mainly Article 2 considerations. This was the 50th judgment which the Supreme Court has issued in the Northern Ireland case since that court was established just 15 years ago. So we've been punching well above our weight, and we're doing so long before that in the House of Lords. More than half of these appeals have involved issues relating to human rights law. Many of those decisions have had a significance that resonates throughout these islands. JR 123 is striking because the Supreme Court took the opportunity to remind lower courts once again of the constitutional limits on their powers under the Human Rights Act 1998. In today's proceedings, that theme first surfaced in the presentation of the Shadow Attorney General. Declarations of incompatibility are the unique remedial mechanism established by Section 4 of the Human Rights Act en passant. One will find the same in Section 5 of the Republic of Ireland Human Rights Act, which of course coexists with the Constitution, which the Human Rights Act does not do in the United Kingdom. Since the Human Rights Act was commenced 25 years ago, there have been more than 50 Section 4 declarations of incompatibility made by the domestic courts of the United Kingdom. Northern Ireland, disproportionately, has managed to produce 14 of those, no less. In addition to Section 4 human rights declarations, the Northern Ireland courts and the UK courts generally have also made what I might call non-Section 4 declarations, sometimes labelled common law declarations of incompatibility, disapplying subordinate legislation, and indeed in Northern Ireland we have found primary acts of the Northern Ireland Assembly to have been enacted without legislative competence because of an incompatibility with convention rights. That's for the 14 cases. Come in. The most recent case arises out of a declaration of incompatibility under Section 4 made by the Northern Ireland High Court in February 2024 in Dillon and others. That concerned declarations of incompatibility in respect of a whole series of provisions of what I'm just going to call the Troubles Legacy Act, which, as many of you probably know, is no more. The fact that it is no more, of course, has not precluded the Supreme Court from recently considering the appeal from the decision of the Northern Ireland Court of Appeal, which in broad terms agreed with the High Court. Judgment was handed down on the 20th of September 2024, and indeed the Northern Ireland Court of Appeal, in parenthesis, I wasn't a member of it, went further than the High Court and included a number of other provisions of the legislation in question. It may be said that this suite of decisions suggests a markedly interventionist approach by the Northern Ireland courts in respect of provisions of primary legislation that have been enacted by the Westminster Parliament. Some of these decisions are, beyond any shadow of doubt, constitutionally groundbreaking, not only as regards Section 4 of the Human Rights Act and declarations made thereunder, but also the Windsor framework. Unfortunately, I can't dwell on that just now. But let me turn the attention then to the Supreme Court. The 15th of December 2021 was a landmark date for human rights law in the domestic courts. In a sentence, it was a landmark date because a step back was taken. On that date, the Supreme Court handed down judgment in the case of Aileen Kane, reversing a House of Lords decision in a Northern Ireland human rights case called Ray P. Just another word about that in just a moment. But perhaps significantly, the Supreme Court on the same date also handed down judgment in two, one might say, progressive decisions of the Northern Ireland Court of Appeal in McQuillan and McKenna, reversing that court's approach to the temporal limits of Article 2. I'm delighted to say again, the work of my predecessor, nothing to do with it. And the case in question, Ray G, had been in the law reports for a period of over 15 years at that stage. The issue in Ray G was whether anyone other than a married couple could adopt a child. The Northern Ireland legislation said no, in black and white terms, you've got to be a married couple. The House of Lords reversed that in broad terms, making a declaration of incompatibility by a majority of 4-1. The point was that the Strasbourg jurisprudence hadn't gone that far, and the only member of that court who recognised that fact in the minority was Lord Walker. So the decision in Ray G had far-reaching consequences, and the more recent jurisprudence of the Supreme Court has drawn attention to that, and indeed has listed some of the high-ranking judicial decisions in the United Kingdom in which Section 4 declarations based on the reasoning of Ray G were made, and which now, frankly, and in retrospect, are no longer sustainable. So the House of Lords has reached, the Supreme Court has reached that stage in a series of landmark decisions. Aileen Kane was the first. There's time only to give you the shortest of quotations from the decision. Contracting states can, of course, create rights going beyond those protected by the Convention, but that power exists independently of the Convention and the Human Rights Act. It is not dependent on the margin of appreciation doctrine, and it is exercisable in accordance with long-established constitutional principles under which lawmaking is generally the function of the legislature. The more recent decisions of the Supreme Court have been to like effect. Ray A.B., Ray S.C. and others. Another Northern Ireland case, McLaughlin, which had gone the other way, is now, the Supreme Court itself has stated, wrongly decided. We know the Supreme Court doesn't depart all that often from its previous decisions, and this was a unique example of that happened. At the coalface, what were the consequences of the wrongly decided Ray McLaughlin? Well, within a period of a couple of years, Parliament had committed the government, in light of the remedial order which followed, had committed some £200 million to bringing in new statutory benefits, which the Supreme Court later decided should not have been required. Have we got a minute? Thanks very much. Most recently, we have Ray J. or 123 in the Supreme Court, and in a sentence, and commendably consistently, the Supreme Court has now educated all of us regarding Section 4 declarations of incompatibility in the following way. That mechanism is appropriate not where the individual applicant can establish human rights incompatibility in the individual's case, but only wherein, and this is the wording of the court itself, in all or almost all cases across the board, that incompatibility can be demonstrated. As counsel for the government in Ray P or Ray G, it's been called both names, I can recall unsuccessfully advancing that submission to the House of Lords. It has now been fully vindicated, I'm delighted to say. And we've also had the remarkable phenomenon of Northern Ireland courts intervening by making declarations of incompatibility in so-called ab ante cases. And these have emerged, ab ante being one of the very few Latinisms to have survived recent times. Apparently there's no satisfactory English equivalent, at least not so far. But those declarations of incompatibility were made in respect of provisions of primary legislation which had not yet been commenced. Well, the Supreme Court has made pretty clear what they think of that. So finally, while a definitive reset of the equilibrium may not yet have occurred, the direction of flow of post-20 tide in the Supreme Court is clearly discernible. And Dillon was heard recently, as some of you will very well know, and judgment has been reserved. 2 footnotes only. One, the rhetorical question, is this bad for human rights law? Have these been bad days for the Human Rights Act and for organisations such as Justice and Human Rights supporters? Well, I venture to suggest not, because human rights law is nothing if not founded on the rule of law, and these developments in human rights law have occurred in the highest court, acting within the 4 corners of its powers, and have resulted in full, resounding vindication for the rule of law. Just to remind Lord Wilson, by the way, he didn't, I think, engage with that. And the second is the right to human dignity. So there is, buried in the Northern Ireland Court of Appeal decision in Dillon and others, a passage dealing with the right to human dignity. And all I will say about that is watch this space. So thank you very much indeed for your attention.
Well, I'm going to speak about another opening up, watch this space type of gap, which is the one threatened by the fact that 2 of our big parties within the UK are suggesting that they might repeal the Human Rights Act and or disaffiliate the UK from the Human Rights Convention. So I want to talk about looking at the common law as a starting point for the protection of human rights. For some time now, judges and academics have placed renewed emphasis on the common law as a, if not indeed the, key source of human rights protection in our domestic law. Of course, that is not to diminish the statutory contribution of the Human Rights Act to the development of the available mechanisms for protecting human rights, or of the ever-developing Human Rights Convention in prescribing what those rights actually are. To the contrary, as Lord Reid pointed out in 2013 in Osborne on the Parole Board, the importance of the Act is unquestionable. I wouldn't dispute that for one moment. I will, however, advance 2 points which may serve to put the acknowledgement of the Act's and the Convention's importance into its proper context. Firstly, when one considers the available modes for securing the protection of human rights in UK domestic law, the starting point must remain the common law rather than the Convention articles themselves. In short, it's the common law which usually provides the cause of action, even if the Act is there to ensure that those causes of action are Convention compliant. Moreover, although it has sometimes been said that the normative reach of the common law is more modest than that of the Convention, the common law in fact often affords either the same or sometimes even greater protections, particularly in horizontal scenarios where private individuals seek to assert their human rights against one another. Secondly, I would suggest that it's precisely because the Act has enriched the scope of human rights protections available at common law over the last 25 years that we shouldn't be unduly fearful about the common law's ability to cope if, for example, the UK were to repeal the Human Rights Act or abandon the Convention. Such actions could not, without much more specific legislation, unravel the accumulation of principles and practical experience derived from 25 years of protecting human rights under the Act, which the common law has already absorbed into its armoury. The notion that it's necessary to look first to the common law as the natural starting point when considering the protection of human rights in UK domestic law is by no means new. The sentiment can be detected in some of the first cases raising human rights issues following the entry into force of the Act, of which Daly against the Secretary of State for the Home Department in 2001 is a paradigm example. In Daly, the House of Lords had to decide whether a blanket policy introduced by the Home Secretary, which required prisoners to be absent from their cells during routine searches for contraband, which included examining their correspondence with legal advisors, infringed a basic right recognised both at common law and under the Convention. In holding that the policy unjustifiably infringed the prisoner's right to legal professional privilege, Lord Bingham notably adopted an analysis which was premised almost exclusively on the application of common law principles. Indeed, only in the concluding paragraph of his judgment did he recognise that the same result might obtain if one applied Article 8 of the Convention instead. Lord Coke went even further. In his concurring judgment, he said, and I'm quoting, "It's of great importance, in my opinion, that the common law by itself is being recognised as a sufficient source of the fundamental right to confidential communication with a legal advisor for the purpose of obtaining legal advice. Some rights are inherent and fundamental to democratic civilized society. Conventions, constitutions, bills of rights and the like respond by recognizing rather than creating them." Over 20 years later, this attitude largely continues to be displayed in the Supreme Court's observations on the point. For example, in Abbasi against the Newcastle upon Tyne's Hospitals NHS Foundation Trust in 2023, Lord Reid and I, in a joint judgment, noted at paragraph 87 that, quotes, "domestic causes of action are the means by which compliance with convention rights is normally secured," end of quotes. Moreover, senior judges have consistently recognised that notwithstanding the Act's importance and galvanising effect on the development of human rights protections at common law, it was neither the Act's purpose nor its effect to supplant, supersede, or sideline the common law. That said, in some instances, the values underlying convention rights have inspired or even replaced the relevant legal conditions for the assertion of common law causes of action which protect human rights. And to that extent, convention rights may be regarded as having enriched the common law. Arguably, the most striking example of this is the development of the law of privacy. Traditionally, the protection of privacy at common law has been piecemeal, principally owing to English law's reluctance to adopt a general tort of breach or invasion of privacy. Instead, the law protected privacy interests by employing a patchwork quilt of common law and statutory causes of action. As Lord Hoffman recounted in Wainwright and the Home Office, there are several common law and statutory remedies of which it may be said that one at least of the underlying values they protect is privacy. For example, common law torts such as trespass, nuisance, defamation and malicious falsehood, and the equitable action for breach of confidence. However, as Lord Hoffman also recognised, there may be gaps where the courts consider that a remedy should be available in respect of a breach of privacy, but no such remedy currently exists. The case of Kay and Robertson in 1991 provides a vivid example of the difficulties the courts faced in endeavouring to protect privacy interests prior to the Human Rights Act. Kay, a well-known actor, had suffered a serious brain injury following an accident in which a piece of wood had smashed through the windscreen of his car during a storm. While Kay was recovering from surgery, journalists gained unauthorised access to his hospital room and proceeded to interview and take photographs of him. The medical evidence before the court was that Kay's health was such that he could not have consented to the interview, and indeed, he had no recollection of the journalist's visit merely 15 minutes later. In short, the journalist took a disgraceful advantage of his vulnerable state to get their scoop. However, since English law recognised no general cause of action for breach of privacy, the court couldn't grant Kay a compensatory remedy in respect of the journalist's intrusion into the hospital room, which he didn't own, nor could it grant an injunction to prevent the newspaper from publishing the story. The best the Court of Appeal could do was to rely on the law of malicious falsehood to grant an injunction prohibiting the newspaper from implying that Kay had permitted the photographs to be taken or given the interview voluntarily. Lord Justice Bingham considered this a particularly regrettable result and stated that the case was a further illustration of the failure of the common law of England and statute to protect in an effective way the personal privacy of individual citizens. Additionally, prior to the Human Rights Act, a similar lacuna could be observed in relation to the equitable action for breach of confidence. Historically, an action for breach of confidence could only be made out where there had been a pre-existing confidential relationship between the claimant and the defendant, although admittedly that requirement had been relaxed a bit over time. Importantly, however, the action did not depend upon the personal nature of the information itself or the extent of its publication. The enactment of the Human Rights Act and its effect of spurring the development of the common law meant that such gaps were subsequently addressed. In Campbell and NGN in 2004, Lord Nichols recognised that the cause of action for breach of confidence had firmly shaken off the requirement for an initial confidential relationship, and that the essence of the tort should now preferably be characterised as misuse of private information. Since then, a growing body of case law has developed on the content and application of the relevant legal test to establish the tort, including some cases in the Supreme Court. Here, the Act and the Convention articles have clearly made their mark on the common law. To succeed in an action for misuse of private information, it must firstly be established in substance that the claimant's right under Article 8 is engaged. In other words, the claimant must have had a reasonable expectation of privacy in respect of the information in question. Once this threshold is met, the court secondly engages in a balancing exercise, or what lawyers call a proportionality analysis, in which it weighs the claimant's now common law and Article 8 right to privacy against other countervailing justifications, typically the defendant's historic common law and now Article 10 right to freedom of expression. Another example of the beneficial absorption of convention principles into the common law may be found in the principle of proportionality, particularly, but not only, in shaping public and administrative law thinking. As Professor Mark Elliott acknowledged in 2015, whereas around 25 years ago proportionality was considered by some to be novel and dangerous, the court's experience of proportionality review under the Human Rights Act has served to normalise and demythologize it in a way that sits uncomfortably with its characterization as a European import that would depart the UK's shores in the course of a process of de-Europeanization. He, of course, was thinking at that stage of Brexit. Indeed, he recognises astutely that proportionality has been implied in human rights cases decided at common law, such as Daly, which evidences the capacity of the proportionality principle to operate legitimately as a common law tool, quite outside of cases purely concerning convention rights. Proportionality may now be found at work in other private law areas, such as shaping the remedy available in proprietary estoppel, and assisting in the exercise of the equitable discretion, whether in a particular case to grant or withhold an injunction. Nonetheless, we are still a long way from any general recognition of proportionality in the public law sphere, for example, as potentially replacing irrationality as a test for judicial review, because of its tendency to focus too much on the merits of administrative decision-making. So to conclude, I note that there are admittedly some key differences in the relative strengths of common law and convention rights. For example, the Human Rights Act provides for several protective mechanisms to ensure as far as possible that convention rights are not overridden by conflicting legislation. Section 3 of the Act requires the courts as far as possible to read and give effect to legislation in a way that's compatible with convention rights. By contrast, no similarly strong interpretative principle applies in relation to human rights secured at common law. Moreover, Section 4 of the Act enables the court to make a declaration of incompatibility where primary legislation conflicts with a convention right, and no analogous power exists at common law in relation to fundamental rights. there is a legitimate concern that these types of statutory safeguards for human rights would be lost if the UK jettisoned the Act. Yet this doesn't mean that human rights, also recognised as fundamental rights at common law, would be entirely unprotected against legislative, let's say, over-enthusiasm. This is because the principle of legality requires, among other things, that if Parliament truly intends to derogate from common law fundamental rights, it must manifest that intention through express language or by necessary implication. Viewed in this way, this principle of legality requires the courts to adopt an approach to the interpretation of statutes that is broadly comparable to the approach under the Human Rights Act, although less radical in its practical application. This affords fundamental human rights recognised as such at common law a degree of protection, albeit one that is weaker than under the Act. So I'll close by recalling a quote of Lord Justice Toulson, as he then was, who said in 2012, "The development of the common law did not come to an end on the passing of the Human Rights Act 1998. It is in vigorous health and flourishing in many parts of the world which share a common legal tradition." I think he was right, but also that while the common law remains the first port of call for the protection of many human rights in domestic cases, it has undoubtedly been greatly enriched during the last 25 years of the Act's presence on the statute books. Thank you.
So the question I'd like to ask our panel is around the role of the judiciary. We're talking about the Human Rights Act and the fact it's the 25-year anniversary since its commencement. How can the judiciary play a role in improving public understanding of human rights law in general and how it operates in practice?
Well, I think events like this are important. Opportunities to communicate off the bench are important. I think perhaps the most important thing we can do is write our judgments, write them clearly and publish them, because that's a window into what happens. The other thing that I think's perhaps really helpful is the increased potential that we have now for more people to watch courts with the aid of technology. In the inner house of the Court of Session, which is it's like the Court of Appeal. A great many of our cases are live streamed now, particularly public law cases of interest, but not just. So there's, again, that window to come and watch exactly what we're doing. So please do.
For me, judgment writing would be right at the very top of the list. I think we are very slowly emerging from a culture in the judiciary where we are now more acutely aware than ever of the vital importance of communicating with society in the clearest possible terms. And the secondary mechanism is via whatever extrajudicial activities we are able to undertake, whether that be at universities in particular, or with law students, marshalling, or at important events of this kind.
Michael.
Well, I agree with what's been said about outreach. In the Supreme Court, each of us every term spends an hour, usually remotely, with a school, a sixth form part of a school, answering very searching questions, which luckily they send us a day or two in advance to give us time to prepare. Public legal education lies absolutely at the heart of all this, and we don't do very well on it in this country. Yep. I think us judges in the schools and the outreach we do are really just scratching the surface. I also agree a lot depends on how we do our judgments. In the Supreme Court, if you're doing a lead judgment, you then have to do a 10-minute oral hand down in simple language that anybody can understand. And I often look at my note for the hand down and my judgment and think, why on earth didn't I write the judgment like the note? But there's an important point there, and I think our judgments have been responsive to that sort of comparison. We must not just write for the parties or for the legal academics. We must write in a way that's intelligible. And finally, I would say, making our court processes more transparent. For the whole of the life of the Supreme Court, we have live streamed our hearings. But if you just watch the live stream, or even if you turn up, the parties are all referring to documents which are not read out in court, and so that the process very quickly becomes unintelligible. This year, in a new set of rules, we've introduced a principle that the statement of facts and issues in the Supreme Court, which tells you what the thing's all about, and the parties' written cases, which are their main submissions, which usually quote the main bits from law reports and the main documents that we're arguing about, go onto our website 10 days ahead of the hearing. So if you can see an important human rights hearing coming up, it doesn't matter whether you're a lawyer or an academic or a journalist or just an interested member of the public, you can actually pre-read in much the same way as the judge has pre-read. You can take your laptop into court if you want to be there, or have twin screens and have it beside you when you're watching the hearing and look at the documents that are being referred to. And I think that takes an enormous leap in improving transparency. And there comes a day when I would like the whole court file to be available, subject only to the redaction of things which are genuinely confidential, when we can work out who pays to do the redactions, or until OpenAI gets so good at it that they'll do it for us for free.
Thank you. Questions from our audience? Do just wait for the microphones, just so people online can hear. Thank you.
Good afternoon. Very nice to see all of you here. I had a question for Lord Briggs, but I'd be very interested to hear what the rest of the panel think as well. I was personally involved in a high-profile appeal to the Court of Appeal, which I spoke to Lord Briggs about during the break, in which, the adult disabled parents of divorced parents, adult disabled children, divorced or separated parents, are able to apply for financial relief against their parents, but not the adult disabled child of married or together parents. Subsequent research revealed that over 50 countries in the world, this was banned, completely banned, like this, we're the only country that does it. Nonetheless, we went in front of Lord Justice Underhill, Lord Justice Moylan, and I think it was Dingemans, and we lost. And we were incredibly surprised because we had a very strong lead counsel from Matrix Chambers called Hugh Southey KC, who thought it would be a complete no-brainer. The question I want to ask Lord Briggs today, and the rest of the panel, if I may, is do you think when it comes to human rights issues, which are so fundamental, particularly Article 14 discrimination, don't you think there ought to be another layer of review? So, for example, if you are rejected by the Court of Appeal, your only option isn't to go, for example, to the European Court of Human Rights, but the Supreme Court should be able to review it and say, has there been a mistake made here? Is there something that we can do about it to fix it before some poor chap has to wait for 5 years or 6 years to go to the European Court of Human Rights? And the second question is the person who did the judgment in my appeal was a chap called Lord Justice Moylan, who had a family law background. And one of the banes of, I'm sure, many of the lawyers who are sitting in this room, is that some of the Court of Appeal justices decide cases in which they have no specialist background. And so, for example, you see it in tax appeals, because I used to work in tax, where people who are non-specialists in tax decide tax matters, and they often get it wrong. Does Lord Justice Briggs agree with me that such matters, which are very specialist in human rights, should go to specialist human rights judges who've been human rights practitioners before they came to the bench? So those are my questions.
Well, let me take the second one first.
Yes.
To which I would, with respect, say no. We only have 12 Supreme Court judges, and in terms of the specialisms which we try and bring to the table, which will largely be specialisms which we achieve while as a first instance judge or a practice at the bar or as a solicitor or whatever, you simply couldn't have whole panels of 5 which contained all specialist judges. But we do specially choose all our panels, not with a view of loading the panels to produce a particular result, but with ensuring that to the extent that we do have one or more specialists on the relevant subject, then yes, one or more of those specialists will be on that panel. I'm not by any stretch of the imagination. Well, the Court of Appeal does things in a different way, and I'm not going to comment on the way they do it. But coming back to your first question, another layer of review. I mean, there is the Supreme Court layer of review. You only get to the Supreme Court from the Court of Appeal, obviously, if you can get permission, either from the Court of Appeal, which is very rarely granted, or from the Supreme Court. But we do look at all the incoming cases in which permission to appeal is sought very carefully. We always, we look at the papers, we look at the judgments, and we sit in groups of 3, not in public, but to decide whether a permission should or shouldn't be granted. So, I mean, one of the great advantages of the Human Rights Act, it brought human rights law on board as part of our law, so that you can go all the way to our Supreme Court if you've got a dispute about it. Doesn't necessarily stop you then going on to Strasbourg, but you probably get there much sooner to come to the Supreme Court than to Strasbourg. I'm not going to comment on the particular facts of your case, I'm sure you'll understand.
We've got literally a couple of minutes left because we're slightly overrunning. Is there any other questions? Otherwise, I do think all of our judges may be sticking around for a little bit afterwards, aren't you? So, yes. So you can have an opportunity to... There's one at the back. We'll take it. Hopefully it's a quick one, and we'll take your question and then we'll wrap up. Thank you.
Hiya, it's Jim Rowbottom from Matrix. I just want to ask something about Lord Briggs's point about writing judgments in an open way that the public can understand, that aren't lawyers. Earlier in his talk, Lord Justice McCloskey said, so-called ab ante. And in the Abortion Zones Access case and the current law authorities on ab ante challenges, etc., in Section 4 of the Human Rights Act, you see the word ab ante a lot.
Sorry, the word?
The term ab ante. I'm probably saying it wrong.
Oh, ad ante. Oh, yes, yeah.
Yes, yeah. Well, there you go. I'm lucky enough to have become a barrister, but I'm from a North London comprehensive school, and the comprehensive schools who Lord Briggs you speak to won't be taught Latin.
No.
I've just checked the Abortion Zones Access case, and Lord Reid does explain clearly what ab ante means. But we could, and presumably it's the kind of thing that courts at your level would be able to do, just get rid of Latin, couldn't we now?
Well, Latin has officially been got rid of in all the courts below the Supreme Court.
Yeah.
But one of Lord Neuberger's first acts as President of the Supreme Court was to make sure that it either was brought back or not got rid of in the Supreme Court. In his defence, I mean, I did Latin to A-level, but ab ante is still something I'd have to go and look up, at least for its legal significance. The point is that these phrases that have been used for hundreds of years have accrued a patina of meaning, so that the use of 2 words says a whole lot to a knowledgeable lawyer. And it does shorten matters to be able to use that kind of jargon. That said...
But only for us.
Exactly. And as Lord Reid explained what it meant in that case, otherwise there are cases which are simply so complicated, in which the oral hand-down or the press summary, which is a slightly more sophisticated summary than the oral hand-down, is what, at least for starters, the public can go to. And of course, they can just stuff it into ChatGPT and ask it to produce an intelligible summary. And believe me, it will in about 30 seconds. Whether it'll be right or not is another question. But it'll be a good stab at it.
On that note, I'm going to say thank you, and I invite you to show your appreciation to our panel.
Well,